Hi, everybody. Welcome to another one of Legal Aid Service of Collier County's Lunch and Learn series. Today's topic is going to be on security deposits. Probably everybody has been a tenant at some point in their lives. And if you've been a tenant, then you probably had to pay a security deposit. In Florida, the law about security deposits is very specific, and it's to everybody's best interest, both landlords and tenants, to know what the obligations and the rights are to security deposits. Today's session is sponsored by my office, Legal Aid Service of Collier County. We're a nonprofit law firm here in Naples and Immokalee. There are probably lots of similar organizations where you live outside of Collier County. In any case, we represent people who, mostly tenants, but today's session is really aimed at both landlords and tenants. Today's session is being recorded so that if you miss a part of it or you want a friend to listen in on it, it's going to be available. You can link to it on YouTube through our website or any of our social media accounts. Although this is being recorded, we aren't recording you, so it's only a one-way thing. If you've got questions though for me, please feel free to put them into the chat box, and we'll get to them as soon as we can. So let's dive in. Security deposits. Everybody is obligated to follow the law. Landlords and tenants must follow what is required by the Florida statutes. If there's a written lease between the landlord and the tenant, then the parties have to follow that too. But what happens if the two are in conflict with each other? What if the statute says one thing, but the lease says something else? Which one controls? Almost always, it's the statute that's going to be the thing that controls. If you don't, most people don't have a copy of the statutes around, but it's easy to find Florida Statute Section 83 by going onto the web. And as for your written rental agreement, if you've got one, you better hold on to that copy, because at some point when a question does come up, the first place I want to look is to look at the lease. So don't lose it. Be sure you have a copy of it in a safe place. And on that note, keep in mind that it is perfectly valid to rent a place without having a written agreement. An oral agreement to rent premises is enforceable. The problem, of course, is that when it's all verbal, all oral, people forget what it says, or there's a confusion, whatever. So much better to have it in writing. So this is the statute, or actually it's only part of the statute. Can you read it all? No, of course not. It's just too much. It's just too much to read and soak in, because it covers so much ground. So what we're going to do today is kind of get rid of all the clutter and focus on the most important parts that you as a tenant or you as a landlord need to know. Let's start when the lease begins, when the tenancy begins. When you first rent a place, usually there's a written lease. And in that lease, it will say something like, the rent's going to be $1,500 a month, due on the first of the month. There's going to be a late charge. You can't have pets, all that sort of stuff. And then it might say the tenant is paying a security deposit of, let's say, $1,500. According to Florida statute, the landlord has to put some additional information into a writing. Usually it's the lease, but it could be something separate. Has to put it in writing, some other information about the security deposit. The landlord has to give you the name of the bank where he's keeping the security deposit. and the address. Now, the address, it's sufficient if it just says Bank of America, Naples, Florida. That's sufficient. They have to give you the name and address of the bank. The only exception really is if the landlord has, instead of putting the money into a separate bank account, they post a bond. That happens very, very rarely. And for most of the people who would be listening to this presentation, it just doesn't matter. At the beginning of the tenancy, the landlord will tell you where the security deposit is being held. The landlord also has to disclose to you in writing whether or not there's going to be interest paid on the security deposit. In other words, in my example of $1,500 security deposit, the landlord takes it, puts it in Bank of America, keeps it separate, and holds on to it for as long as you're a tenant, maybe 2 years. What about the interest that might be earned on that money? Because usually when you put money in a bank, it earns interest, right? If the landlord doesn't have to give you the interest, but if he has to tell you that he's going to do that. So if the landlord is going to give the interest to the tenant, he has to say it at the beginning of the tenancy and put it in writing. The statute says that that the landlord also has to put in writing to the tenant all of the tenant's rights regarding the security deposit. And usually that means putting in a copy of the actual statute, this one that I said is just too hard to read or too complicated. That's the kind of thing that they would be most likely to attach to the lease or to write it into. But the reason that that's there is because the legislature wants tenants to know what their rights are to the security deposit. So if you're a tenant and it's the beginning of the tenancy, look through the lease or look through some writing from your landlord to see where your security deposit is going, whether you're going to get interest on it, and what your rights are to the security deposit when the tenancy is over. And if you're the landlord, at the beginning of the tenancy, you want to put all that information in writing to the tenant and keep a copy of it. You want to tell the tenant where the security deposit is being held, whether you're going to be paying the interest to the tenant, and you need to include a statement about the tenant's rights to the security deposit. Now, a lot of people pay advance rent in addition to a security deposit. So in other words, when you start your tenancy, many times the landlord charges first, last, and security deposit. That last month's rent, that's called advance rent. It is not the same as a security deposit, but it's very much like it. Advance rent has to be kept separate the same way that a security deposit does. The difference is that as the advance rent becomes due, the landlord can simply pay it to himself without doing any notice to you. So in other words, in my example where you've paid a security deposit of $1,500, let's say you've also paid the last month's rent of $1,500, and your lease is going to go until December of 2022. Well, when December 1 of 2022 comes along, you tenant don't have to pay rent to the landlord because the landlord already has it. The landlord can collect that December 2022 rent directly from the account where he's been holding it. And he doesn't have to tell you that he's doing it because it's all understood from the very beginning that it is advance rent. Okay? So advance rent has to be kept separate, like a security deposit, has to be kept in the same way that they keep a security deposit. The difference is that when that rent becomes due, the landlord can just kind of collect it from where he's holding it. But the tenant cannot demand that the security deposit be applied to rent that's owed. So let's say you sign a lease now, it goes until December of 2022. And you paid it the last month's rent. But things get difficult for you and you fall behind on rent in March. And so you say to the landlord, look, you've got my last month's rent, go ahead and use it for March. You are not entitled, you, the tenant, are not entitled to do that. The landlord can say, nope, that is for the last month on the lease. You cannot use it for other unpaid rent. So if you're in that situation where you've paid a last month's rent and you want to use it before the last month, the landlord does not have to cooperate with that. So let's skip all the way to the end, to when you move out. The landlord has two options about the security deposit. Either the landlord has to return the security deposit to the tenant no later than 15 days after the tenant moves out. Or the landlord can mail a claim on the security deposit within 30 days of the tenant moving out. In other words, in my example, the lease goes till December 2022. Tenant moves out very last day of 2022, December 31st, 2022. The landlord goes in, inspects the place. It's perfect. It's perfectly clean. There's no damage. No money's left owing. And so the landlord, within 15 days, no later than January 15th, has to mail that money back to the tenant. Here's your security deposit. Everything's good. But if the landlord goes in on January 1 and says, oh my gosh, this place is damaged. There's this, they left some rent unpaid. They have to clean, all this sort of stuff. Then the landlord has to make a list of those things that he's claiming, and he has to mail it by certified mail to the tenant no later than 30 days after the tenant moved out. And that, in my hypothetical, that's January 30th. So I think probably most tenants get a claim on the security deposit rather than the whole security deposit back. But those deadlines are very, very firm. And it is important to make note of those because the parties' rights and obligations are directly affected by these deadlines. If the tenant is going to get the whole security deposit back, then it has to be returned within 15 days. If the landlord is saying, no, you're not going to get it back, or you're not going to get all of it back because of this or that, that letter has to be sent by certified mail within 30 days. So the landlord has no obligation to send that claim within 30 days if the tenant did not give a forwarding address at least 7 days before moving out. Now, this is actually a little bit of a tricky part of the statute because this part of the statute can be read in a couple different ways. It very literally says the tenant should give a notice 7 days before moving out in writing saying this is where you should send any or where you should forward any mail. It doesn't have to be where the tenant is moving to. It just needs to be a mailing address. And if the tenant does not do that, the landlord can say, hey, I don't have to follow those deadlines because you didn't do the step you were supposed to take, so I don't need to follow those deadlines. That's one way to read it, but a lot of judges read it a different way to say, no, regardless of whether the tenant gives the address or not, the landlord still has to follow those deadlines. And we'll get into the consequences of what those deadlines mean if they're missed. So a smart tenant, though, smart tenant will always give a forward mailing address in writing. Always, always, always. Don't think that, oh, I told him I was moving, to my mother's house in Pensacola. No, put it in writing. This is the mailing address. And of course, keep a copy for yourself. A smart landlord will always send a claim regardless of whether he gets the notice from the tenant. So let's say that a tenant just moves out, doesn't communicate, just skips out even. What the landlord should do is still send a claim, even if the only address he has is the place the tenant just moved from. Because the landlord will want to have the protection of saying, look, I did what I could. I sent a notice by certified mail to the last known address I had for this tenant. And you'll see why in a little bit, why that's a good thing to do. If the landlord claims the security deposit, the tenant has to spring into action. So let's say, in my example, my hypothetical of the landlord makes a claim on the security deposit after the tenant has moved out, and the tenant gets the form, and it says that the sink has been damaged, the place was dirty, it took hours to clean up, floor tiles are missing, whatever. And for all of that, I'm keeping your $1,500 security deposit. If the tenant disagrees with what the landlord is claiming, the tenant should respond in writing, and should do it within 15 days after the tenant got that claim letter in the mail. So if the tenant gets the claim letter on January 30th, I have to think how many days are in 30 days. Let's say he gets a claim form on January 31st. The tenant should respond no later than February 15th in writing that says, I disagree. I did not damage the tiles. That damage was there when I moved in. I did clean the place, and I have pictures to prove it. Whatever disagreement you have with what the landlord's claiming, put it in writing and mail it back to the landlord. Now, when the landlord gets that objection and he's not convinced, or you haven't changed his mind, you, the tenant, have not changed his mind, he still wants the security deposit, he's not going to send it back to you, then the tenant's option at that point is to file a lawsuit in small claims court in Collier County. So let me go back through these steps again. Let's say the landlord sends you a claim within 30 days of you moving out. He says he's going to keep the security deposit. You don't agree with him, so you write back to him and say, nope, you're wrong. I should get it back. But the landlord just doesn't respond or says no way. Then you, the tenant, have the option of suing the landlord to get the money back. If you don't send an objection to the claim, let's say you get the claim letter in the mail, and yeah, you disagree with it, it makes you mad, but you don't do anything about it, then the landlord can presume, after 15 days, can presume that there is no objection, and he'll take the security deposit from where he's holding it at Bank of America or wherever it is. If he takes less than the full security deposit, the landlord should return the balance to the tenant. So in my hypothetical, where there's a $1,500 security deposit, the landlord says, hey, there were missing floor tiles. It cost me $300 to replace them. And so I'm taking $300, and here's the other $1,200 back to you. Okay. Now, all of that is telling the landlord what the landlord can do with the security deposit that he has been holding separate during all of this time. If It doesn't mean that you can't sue to get it back. It just means that he's entitled to collect it. So let's say that you, the tenant, do not file an objection to the claim, and a year goes by, you still have the right to sue him to get the security deposit back. It's just that at that point in time, the security deposit's no longer there, right? The landlord has taken it from where he was holding it at Bank of America. And so if you were going to sue the landlord, the money would come directly out of his pocket, not from where he's holding the security deposit. That gets that's a little bit like splitting hairs, but it makes the best way to deal with it is, if you're going to object to the claim in writing. Now, this is where the consequences of missing a deadline really come into play. If the landlord does not send the claim form by certified mail within 30 days, then the landlord has to return the deposit to the tenant. In other words, you miss that deadline, you don't get to hold the security deposit anymore. It goes directly to the tenant. And this is true even if the tenant destroyed the place. The tenant owes thousands of dollars in rent. If the landlord has missed that 30-day deadline, the landlord must return the security deposit to the tenant. Now, the landlord still has the right to sue for all the other damages, but the security deposit, what that he's been keeping in Bank of America, that has to go back to the tenant. Now, if that seems a little bit illogical, it is a little bit, but it's there nonetheless. And that 30-day deadline is like written in stone. So don't ever, if you're the landlord, don't ever miss that 30-day deadline. If you, the landlord, happen to miss that deadline, and it pays to kind of work something out with the tenant and try to resolve the problem. And in fact, the statute itself encourages both the landlord and the tenant to try to work out any differences of opinion between themselves before they jump into court. But that 30-day, and the other consequence of the 30-day deadline is not only is the tenant entitled to the return of the security deposit, but if the tenant has to hire a lawyer to get it back on the basis of missing the deadline, the tenant is going to be able to collect attorney's fees for all of that work, attorney's fees and court costs. So suddenly the landlord not only is paying over $1,500 to the tenant, but maybe at least twice that much, because they're also paying attorney's fees and court costs. The lesson: don't miss the deadline. So here are some tips for the tenant. When you move out, give a forwarding address in writing to the landlord. Do it early. It doesn't have to be where you're going to live. It has to be a mailing address. Don't do it by text. It's not so good to do it by email. Do it in writing. Hand it to the landlord. Mail it so that it arrives to the landlord 7 days before you move out. But put it in writing and keep a copy for yourself. Because if you don't do that, and the landlord later says, hey, I didn't have to follow those deadlines because I never got it, why deal with that argument? Put it in writing. When you move out, remove all personal belongings and trash from the unit. Clean the unit. A lot of times tenants will move out, but leave behind stuff that they don't want. I don't want that bed frame anymore. I'll just leave it for the next person. Or I don't want clean it all out, because what you think might be useful to the next person could very well just be seen as trash that the landlord has to remove. And if the landlord has to work to remove trash from the unit, you could be held financially liable. So remove all personal belongings from the unit and clean the unit. It's a good idea to take pictures of the place as you vacate, especially places, little spots in the place that might be a bone of contention. Like during the tenancy, you kept complaining to the landlord about the dripping air conditioner, and you might want to take a picture of that part of the wall to show, what you were talking about all those times. If you know that the landlord thinks that you've destroyed something, take pictures of that area so that you can show that it's the way that you believe it to be, not what the landlord might be saying. Return the keys to the landlord. Don't just skip out in the middle of the night and just say, hey, I moved out on Sunday. But if you haven't returned the keys to the landlord, then how is the landlord to know for sure that you are totally out? Traditionally, the return of the keys has been the symbol of possession. So as a tenant returns the keys to the landlord, in legal terms, the tenant is surrendering the premises back to the owner. So return the keys and remember what day you do it on. Tips for the landlords. Pay attention to the deadlines. I could say this 100 times and it still wouldn't be enough. Pay attention to the deadlines. Pay attention to the deadlines, because the consequences of missing the deadlines is having somebody like me bring a lawsuit to get the security deposit, payment for all my time, and all the court costs. So don't miss those deadlines. Charge for damages, not normal wear and tear. The tenant is responsible for anything that is beyond normal wear and tear. Some tenancies last for years and years, and so repainting the place, that is kind of normal wear and tear. I can recall a case where tenants had lived in the premises for 10 years. When they moved out, the landlord made a claim, included on the claim, painting the unit. Well, painting every 10 years is not extraordinary. That should be considered normal wear and tear. On the other hand, I've seen cases where somebody has been a tenant for, less than a year, and there's all kinds of crayon and paint marks on the wall from, whatever activities, and the landlord has to repaint because of that. That could be considered damages that could be assigned to the tenant. But if the landlord is replacing carpet that has been there for 10 years or so, that is normal wear and tear. That should not be on a security deposit claim. That's just the cost of doing business. The landlord, just like the tenant, the landlord should take pictures of the unit after the tenant vacates, especially the items that need repair or need the landlord's attention to improve or whatever. Take pictures. And if the landlord is keeping the deposit, always send a claim, always, regardless of whether you got that forwarding address or not. As I said before, if the only address you have is the place that the tenant just left, do it anyway. It seems futile, but for the cost of that certified mail, you might be saving yourself a big headache down the road. So always send a claim if you're going to be making a claim. I appreciate you listening in with us on security deposits. If you are in need of individual legal help, please give us a call or contact the Florida Bar or the Collier County Bar Lawyer Referral Service. There are lots of people out there anxious to help landlords and tenants meet their obligations under the law. We're very happy that you participated. We look forward to having you participate in future Lunch and Learn sessions. My name is Kathy Lucrezzi, and I will be signing off now. Have a good day. Thank you.